Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida, and I'm going to talk briefly today about non-compete agreements and arbitration provisions. So let's start with arbitration provisions. Here's the bottom line. Going back probably 6 or 7 years, there has been an unbroken string of Supreme Court case law holding that arbitration trumps. That's really the bottom line. Arbitration trumps. If there's a contract and it contains an arbitration provision, that provision will be given its fullest effect possible. If you have two parties, they have a contract, contains an arbitration clause. If one of those parties files an action in court, the court is going to dismiss that action in favor of arbitration. That's the bottom line. Arbitration trumps. Now, this raises some interesting concerns when you combine arbitration with a non-compete provision. Why? Well, because plaintiffs in non-compete cases are always attempting to avail themselves of the actual courts. They are always going into court and seeking a temporary restraining order or a preliminary injunction. In non-compete litigation, that is often their greatest leverage. The fact that they can enjoin you, they can shut you down, they can keep you out of the market, prevent you from doing business, prevent you from having contact with clients, etc. That's always the big ticket item in non-compete litigation. They're looking to get a preliminary injunction. Now, sometimes you have contracts, an employment agreement, an asset purchase agreement, etc. You have contracts that contain a non-compete provision, and they also contain an arbitration provision. And if the plaintiff has done this correctly, there's going to be a carve-out or an exception that still allows the court to issue a preliminary injunction. And I see this all the time in my practice where it's a contract, here's a non-compete provision, here's an arbitration provision, here's another provision that says even though this agreement is subject to arbitration, the courts of Miami-Dade, Florida shall have jurisdiction to issue a preliminary injunction. Why do they do this? Well, obviously they do this so they can have their cake and eat it too. They can arbitrate the case and get whatever benefits they feel that arbitration entails, and at the same time, they aren't sacrificing their real leverage in the form of a preliminary injunction. They're carving that out so a court still has jurisdiction to issue such an injunction. So if you're in that particular ball game where it's arbitration, it's non-compete, and the court has jurisdiction to issue a preliminary injunction, if you're in that ball game and there's an injunction issued against you, your only play is to get the arbitration as quickly as possible. You want to arbitrate this thing. Hopefully you prevail in the arbitration, and then you can immediately get the preliminary injunction vacated based on the arbitration decision. That's really your only option. But there's a different scenario here where I've also seen people in a situation where the court has no jurisdiction, but the plaintiff is seeking a preliminary injunction. So you have a contract, it contains a non-compete provision, it contains an arbitration provision. It doesn't say anything about the courts having jurisdiction to issue a preliminary injunction. And in spite of this, the plaintiff goes into court and seeks a preliminary injunction. In that instance, you should simply be able to get the case dismissed and compel arbitration. And there should be no entry of a preliminary injunction because the court technically lacks jurisdiction to do so. So these considerations are relevant and should guide your strategy for how you're operating depending on what you have. You have a non-compete, you have an arbitration provision, you have a carve-out for a preliminary injunction. You should weigh all of this when you're making business side decisions. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. If you have a question or a concern about a non-compete agreement, please feel free to give me a call. I'd be happy to talk and help you out in any way I can. Thanks for watching and have a good day.